My name's Sidney Mendelson. I'm the director of the Division of Investment Management. On my immediate left is Tim Cox, a branch chief in the division, and on my immediate right is Laura Bond, special counsel of the branch of insurance products. We'll start off this session with a discussion of custodianship and bonding. Those two items are, again, two badges of protection provided by the statute. Custodianship, there are three types of custodianship, which Section 17F provides. One, a bank qualifying under Section 26 of the Act, which has a minimum of $500,000 in capital surplus. In today's world, a very, very small bank. A member of a national securities exchange, but subject to the rules of the Commission. And three, the registered investment company itself, or self-custodianship, again, subject to rules of the Commission. Now, by far, the most important and most frequently used custodianship is the custodianship by a bank. Unfortunately, the Act does not define what a bank custodianship is. So the staff developed a bank custodianship that was in vogue in 1940, and we took the position that Congress must have meant that type of situation when it talked about a bank custodianship. Now, in the guidelines to S4 and S5, and in the guidelines to N8B1, which refers to forms that are not now used, but still but the guidelines may be used to determine staff policy. The guidelines set up certain conditions of bank custodianship. One of those, generally speaking, the custodianship by a bank consists of what I term a COD policy. By that I mean this, that all of the assets of the company are in this custodianship. That the asset when the investment company buys securities, generally speaking, and I'm oversimplifying it, the bank receives an authorization to pay money, and at the same time it pays no money until the messenger of the broker comes to the bank with normally with a draft attached for the securities which are in the hands of the messenger. The securities are counted, and if they comply with the order that the investment company authorized, a payment is made upon the receipt of securities. We now allow partial orders to be received because several years ago, as you probably remember, there was a tremendous fails situation. So in order to minimize fail situation, they allow the custodian bank to receive partial orders, and of course only pay partially. On the other side of the coin, if the investment company sells securities, the securities are normally taken from the vault and sent by messenger to the place where the money is. on the street, generally speaking, securities follow money. The person with the money payment is the person that the securities seek out. So in the case of the investment company, the messenger for the bank will go to the place where the money is, and that person, generally speaking, will look over the securities and pay the money, and the messenger will then relinquish the securities. That is what is known as a COD system. So that there is very rarely a situation where a broker handles the money of the investment company. It's always in the hands of the custodian, and the custodian does not relinquish securities or money without an authorization from the investment company. Now, as you can see, this is probably the best type of custodianship. But the Act provides for other types of custodianship. One is custodianship by a national securities exchange, and the other, what is known popularly as self-custodianship. Now, both of these types of custodians are not self-operating, but they operate totally under rules of the Commission. Now, these rules, generally speaking, in my view, are archaic, are passé, and don't provide the necessary protection that I would like the investment company to have. They were promulgated shortly after the Act was passed, and as far as I can find, they haven't been changed since that time. So our investment study that is now going on in the division will be examining these rules, and will probably change them. But let me go over the rules with you, and very, very generally, because obviously if you want to know what the rules provide, the best thing is to go to the rules. But I'll generally go over them. And that is, let's go over the first one. That is a custodianship by a member of a national securities exchange. This is what is known as a member firm, a broker-dealer. And there must be a written contract of custodianship, and it shall require that the securities shall be individually segregated and earmarked. That, I want you to note this. It says nothing about all of the assets of the company in this case. Only the securities have to be, if the company chooses a custodianship by a national securities exchange, it is talking only about securities. The Commission wasn't encouraging an investment company to leave its money with any broker-dealer, for the simple reason that broker-dealers have habits of going belly up, and money is fungible, and it would be very difficult to earmark money if you could, and I doubt that if you could. But one of the things that's very important here is that the securities shall be individually segregated and earmarked, so that the investment company securities in a national security, in a member custodianship, has to be separated from all other securities, and it has to be clearly earmarked as being owned by the investment company. Now, this was to provide against bankruptcy by the broker-dealer, and to make certain that these securities were not under the possible jurisdiction of the trustee in bankruptcy for the benefit of general creditors, should the company go bankrupt. And so, under the bankruptcy law, as that has previously been in, This was a very important feature of the bankruptcy law of broker-dealers, that the securities had to be earmarked, clearly defined as the property of somebody else. Otherwise, the investment company would become a general creditor rather than a Seneca trust, if you will. The securities shall be subject to no liens. And in addition, the securities must be verified by an independent public accountant 3 times a year, annually, semi-annually, and 1 surprise audit. The certificate, after the accountant verified him, a certificate must be submitted to the commission of such verification each time. It also provides that the securities must be subject to inspection by the commission, just in case there was any question that the commission could use their inspection powers under the 40 Act. The rule, if a company puts in this rule, decides to choose this type of a custodianship, it in fact gives consent to the commission to inspect and count the securities. And finally, the contract of custodianship must be submitted to the commission and must be ratified annually by the board of directors. As I say, if you're interested, just take a glance at the rule. It's a rather simple rule. 17F2 has to do with self-custodianship. This is the type of custodianship that provides the least amount of protection. It is not used very frequently by investment companies. A good number of SBICs, small business investment companies registered on the Act, use it. But generally speaking, any large company does not use it. Actually, it provides this, that the securities must be maintained in a vault in a bank, supervised by either state or federal authorities. It does not provide, the only types of securities not subject to registration are those that are hypothecated or in transit. Obviously, you can't put the securities in. I don't know why they put that in, because I don't see how you could have the securities in custody in the bank vault if you were about to transfer them. But the only persons permitted by resolution of the board of directors have access to such securities. And this accessibility is limited to 5 persons, either officers or employees. When the vault is visited, it shall be visited by 2 or more persons, one of which must be an officer of the investment company. The rule also authorizes officers of the bank and public accountants to have access, but only when they are accompanied by any 2 persons designated to have access without them.
Sid,
yes.
We have granted a certain number of exemptions.
Oh, yes.
To this, particularly in the case of insurance companies, separate accounts. The argument being that the insurance company's vault is just as good as a bank's vault.
Yes. Well, again, Section 6C is used as a relief valve, in effect. There are many insurance companies which keep their securities in a vault 2 feet thick and on their own premises, and subject to state regulation. As a matter of fact, to put those securities in a bank or to put those securities in any other place would violate state law. Looking again, 6C, as Stan Judd mentioned to you in a previous tape, 6C is used when it's in the public interest to give relief from the act. And here, the Commission, in its wisdom, determined that it would not be necessary to use either a bank custodian or self-custodian or a custodianship by a national securities, but use a type of self-custodianship that was agreeable to the states and provided as much protection as the rules that are now promulgated under 17F. Any questions? In 1970, the Act was amended to provide for a depository type of custodianship. A national securities depository is a place where securities are deposited and transfers are made by book entry. By that I mean, for example, the Laura Bond Fund, Sid Mendelson Securities Company, and the Tim Cox Fund all have securities in there, and they get a receipt for the securities they deposit. If Laura Bond wants to sell securities to Tim Cox, Laura Bond's securities are subtract. The amount of securities that she sells is subtracted on the books and credited to the Tim Cox account. The securities remain stationary, so that the total amount of credits of everybody should equal the amount of securities in the vaults of the depository, or they call upon the insurance company to make up the difference. Now, it was obvious that the Commission was encouraging broker-dealers to enter this type of depository, and it was obvious that the depository system would not work unless the institutions entered it, the banks, the investment companies, and the insurance companies. So, the 17F was amended to allow the investment company to deposit its securities in a depository run by a national securities exchange, or any depository which the Commission shall designate as a proper depository, or it would allow the investment company to give permission, in effect, to its custodian to deposit the securities in a national securities exchange. And the Commission, by Rule 17F4, indicated the ground rules under which the investment company could deposit its shares. Generally speaking, it recognized the depository which was originated by the New York Stock Exchange, and it adopted much of the conditions of that depository with respect to the transfer of securities. This rule was the first of the rules which threw the onus of of implementation on the board of directors. Since this rule did not involve conflicts of interest, it allowed the board of directors to negotiate its own contract for the company, if you will, allowed the company, under the auspices of the board of directors, to contract with the depository company with very few conditions. In the same release, which was release 10453, Investment Company Act release, it recognized the book entry system of the Treasury Department as a depository. As you probably know now, it is with most government securities, T-bills and the like, it is almost impossible to get physical delivery. Or you are credited through a member bank with so many securities, and you sell those securities through a book entry system with another member bank, so that you never have physical delivery of these securities. Now, the purpose, as a matter of fact, the Treasury Department is not issuing, the Federal Reserve System is not using the physical delivery at this time. And as I say, it is almost impossible to get most government securities by physical delivery. The theory was that the movement, the physical movement of securities through the exchange caused stealing and the risk of loss. And it has now been recognized that probably we could not have these 40 million share days with physical delivery. And so far, with the use of the computers, we have not had too much trouble in this area. The only complaints that I have heard so far is in the payment of dividends and in the voting process, the distribution of proxies. And I understand that that the Division of Market Regulation is watching this rather carefully and taking necessary measures to iron out those problems. But suffice it to say that the framers of the statute felt that the securities and assets of the company should not remain with the management of the company unfettered, that there should be restrictions. And as I said, most investment companies of any size at all use the bank custodian system, and I don't know of any company that has deposited their securities in a depository directly. All that I know have deposited through the auspices of a bank, so that on the bank's records you own so many securities of X, so many securities of Y, if you're an investment company, and the bank in turn sends those securities to the depository, and it is credited with so many securities. Now, the rule, one of the restrictions of the rule says that the bank's own securities cannot be integrated with the company's securities, so that there's no problem of segregation here with respect to creditors. People who sue the bank cannot grab the securities of the investment company. There was a tremendous reluctance by the investment companies, and I might say by the insurance companies, to relinquish their securities, because I think they like the idea of the auditor coming in and physically counting the securities at the bank. That reluctance is generally dissipating, and as far as I know, there is now, well, not an avalanche, but there is a steady stream of companies using the depository system. All companies have to use the depository system when it comes to the purchase of U.S. government securities. Now, the other badge of protection, which I point to this afternoon, is the fidelity bonding rule. 17G of the Act authorizes the Commission to require by rules and regulations that any officer or employee of a registered investment company who has access to securities or funds of a registered investment company be bonded by a reputable fidelity bonding house or insurance company in such reasonable amounts as the Commission may prescribe. Now, the Commission has promulgated Rule 17G1 of the statute, which you can find in the current CFR on page 978. This rule generally allows an investment company either to have a separate bond or to have a joint bond with other investment companies having the same, other registered investment companies having the same investment advisor, or and also it allows the investment company to have a joint bond with the management company itself. Now, the question comes up, why did we allow a joint bond with the management company? Why didn't we insist that the investment company have a single bond? Well, the reason we did this is because the words officers and employees is a very deceptive word, and people put on different hats at different times. For example, the presidents of many investment advisors are also the president of a fund. And the question can come up, and has come up, as to whether or not the money was stolen when the person was acting as an employee of the investment company, or as or a president of the investment company, or president of the investment advisor. If both of them are on the bond, then that minimizes the problem. The rule sets forth a minimum amounts. It says the board of directors can set what it can terms reasonable amounts, but the rule has a schedule in which it sets forth the minimum amounts relating to the assets. And for example, I'll give you the two extremes. From up to $500,000, the company must have a $50,000 bond. Over $2 million, it must have $1,500,000 bond.
So
over $2 billion. Now you say, why the difference? A $2 billion company and it only has to have $1,500,000 bond. Well, to steal $2 billion, you have to be pretty ingenious. I mean, you got to have a couple of Brinks trucks, now. One of the obviously we're not trying to since bonds are paid for by the amount of coverage, where we feel that we don't require excessive coverage, but we require what we would term realistic coverage. And one might argue that $1,500,000 is too little. I don't think it is, and the Commission didn't think it was, which is even more important. Now, this joint bond must provide the same coverage that for each investment company on that bond that would be required if the investment company took out the bond by itself. It has, and with respect to that, for example, suppose you had an investment company with assets of $75 million. A $75 million bond $75 million would have a $400,000 bond coverage. With respect, and let's assume that there was a stealing of the management's assets as well as the investment company's assets. With respect to the first $400,000, the investment company would have to have priority on the bond, as though it had a single bond. No matter, but let's assume that each one of them, let's assume that the bond was for $6 million, because each of the investment companies had a considerable amount of assets, and each of them took out, and the bond that was taken out accumulated until you had $6 billion in coverage, $6 million in coverage, rather. There, even though the investment company had a priority of $400,000, if it was the only person claiming under the bond, it could claim up to the $2 million, so that there is an advantage in the joint bond. Now, there are certain tricks in this bond that we put in which the insurance companies don't like. For example, the bond requires a 60-day notice of cancellation to the investment company involved and to the Commission. We have argued successfully that if that notice of cancellation doesn't come into the Commission, the bond is in force and remains in force until 60 days after the notice of cancellation. Now, when we get it, why did we ask for a notice of cancellation to come to the Commission? Well, when we find that the bonding company, for some reason, has canceled the bond, we want to know what reason they've canceled it. Maybe they've had a few claims, at which point we want to get out there on an inspection to determine what's going on. We also want to find out how soon the investment company is going to get another bond. And if it can't get another bond, should we allow it to exist without a receivership, without a bond, without fidelity protection, fidelity bonding protection? And the answer is that we would be very reluctant to allow an investment company to exist for long without a fidelity bond, because you're dealing in fungible assets. Now, there are provisions in the rule with respect to amendments and with respect to the priority that I just mentioned, but I do feel that I have touched the highlights and covered all that is really necessary. Now, fortunately, there have been very few claims, relatively speaking, under the bonds. The bonds have, generally speaking, been a broker's blanket bonds, made for the broker-dealer industry rather than for the investment company industry. The broker-dealer industry has had a lot of claims, and consequently, many investment companies think that they're paying too high a premium. We recently had 2 cases of the same type, in which claims of the investment company were rejected by INA, one of the bonding companies. And both of them worked this way. There was only slight variation in the facts. Only the characters changed. The general facts remained the same. What happened was that a president or an employee of the investment company was bribed by a promoter, or a manipulator, I should say, to buy for the fund real junk, worthless securities, at which point the fund would pay good money for worthless securities. Now, in these bonds, 2 things took place. One was that there was what is known as a trading exclusion. And these bonds did not cover trading unless you paid an additional premium. 2, the bonds covered employees of the investment company. Now, if you visualize all of the securities and all of the cash in the hands of a custodian, it's almost impossible to steal money or securities from an investment company without using a trading type of maneuver. In other words, it's impossible to get the money out unless the money is paid for worthless securities. In the one case that we had many years ago, a person, a treasurer of the investment company, manufactured a company, which he called Broad Brothers and Clark, and continued to issue notes of that company. The first notes were for $35,000. When those notes were coming due, he issued, about 3 days before those notes were due, he had the company purchase a $70,000 note from the from the fictitious company, Broad Brothers and Clark, and he paid off the first note with half of the proceeds of the second note. And he kept rolling over the notes in a sort of a Ponzi scheme until this investment company, it's the Revere Fund, until Revere Fund had paid over $1.5 million in bogus securities, in which some of them were redeemed. They were making a great profit on all these notes, so they thought, but they were all obviously fictitious notes. And our inspectors got in there and merely asked them who Broad Brothers and Clark was, and he said it was asked the fellow who was doing the stealing. We didn't know it at that time, and he says, "Oh, that's a subsidiary of Federated Department Stores." So when the inspector got back here, he looked up Federated Department Stores, and he never saw any Broad Brothers and Clark as a subsidiary. And then we did a Dun & Bradstreet on Broad Brothers and Clark, and it came out to be a fictitious corporation organized in Camden, New Jersey. And who was the organizer of this fictitious corporation? The treasurer of the fund. At which point we went back and recast all of these loans. And once you recast them and put them on columnar journals, you could find that that as one note would become due, another note was issued, and anybody could see it. And now the point of this was that this could be considered a trading operation. Now, the insurance company never had to be called upon because the individual's father and brother made good. I think the total outstanding notes at that time were about $200,000, and so they made good. Nevertheless, we prosecuted, or had the Department of Justice prosecute that case, and the person got a prison term. The point, however, I want to make is that the stealing was by trading, or at least the appearance of trading. It's the only way you can steal. It's one of the very few ways you can steal from an investment company. So when these cases came up and were litigated, the commission went amicus, and it said that the insurance company had the duty to provide a bond that would satisfy the statute and the rule, what is known as a statutory bond. The court, in one case, agreed with us, and in another case, the court in both cases agreed with us. One court gave judgment for the plaintiff, and one appeals court gave judgment for the defendant in two different circuit courts. The court that gave judgment for the plaintiff, the investment company here, took the position that I've just taken, that this was not a trading operation at all, but rather it was a way to steal. It was nothing more than stealing money and using a trade mechanism as the method of stealing money. That the trading exclusion really meant the type of bond that you would take out against a broker-dealer for churning. The other court found for the defendant in two ways. First, they found that it was a trading loss, and even though the individual was covered by the bond, the trading loss exclusion avoided the protection. Then they went into and said, if you take the position that the insurance company must provide a statutory bond, a bond that satisfies the statute, and we so find the individual that stole the money was not an employee of the investment company, but an employee of the management company, and therefore there is no coverage. That is on appeal at the present time. But I just wanted to, recently we gave comments on a bond that the industry has negotiated with the Chubb Insurance Company, which will provide automatic protection for such things as trading loss, and will cover such things as protect the investment company when a person of the management company steals the money. See, the way, as we'll get into it tomorrow, the way investment advisory contracts are set up, the management company, in many instances, contracts to provide all of the employees for the investment company. Unfortunately, when this company filed its registration statement and they asked them how many employees it had, it said none. So the court seized that. So see, it has no employees, and therefore this person is not an employee.
That's very common, isn't it?
It's very common, very common. And we took the position that when you say you're going to supply those employees, those persons are the employees of the investment company, although they're being paid by the investment advisor. The court didn't buy that. So, my suggestion to those of you who might ever make inspections is that when you get a look at that bond, make sure two things are there. One, that the trading loss exclusion is provided for. And two, that the bond is made in such a way that if the management company steals the money, the investment company will be protected. Now, with respect to the latter, our bonding provision, our bonding rule does not provide for that. That's very important. But under Section 36, officers and directors have a fiduciary obligation to do things for the benefit of the investment company. And when they're aware of the problems and don't take care and don't take reasonable measures to avoid such problems, they may well be in violation of their fiduciary duties. So that is the handle we would use. Any questions? If not, we'll go on to the next item.
Okay, the next section we're going to talk about is Section 26 of the Act, which deals with unit investment trusts. You recall that a unit investment trust is defined in Section 4.2 of the Act as an investment company which is organized under a trust indenture or a contract of custodianship or a similar instrument. It has no board of directors and issues only redeemable securities which represent undivided interest in a unit of specified securities. Years ago, unit investment trusts were mainly front-end loaded contractual plans for the accumulation of fund shares, but more recently there's been a proliferation of different types of funds organized as unit investment trusts, including municipal bond funds, corporate bond funds, and the separate accounts of insurance companies that issue variable annuities. Section 26 provides that the securities of a unit investment trust can't be sold unless the indenture or other instrument pursuant to which the trust is organized contains the terms prescribed in Section 26A. And the first is that the trustee or custodian must be a bank with an aggregate capital surplus and undivided profits of at least $500,000. As Sid mentioned, that's a very small bank in today's terms. The trustee or custodian, of course, will charge a fee, and it may collect its fee against the income of the trust or the corpus of the trust if the income is insufficient. But the trustee can only charge for or collect for services already rendered or expenses actually incurred. And finally, the trustee or custodian may not make any payments to the sponsor or the underwriter of the trust, except as compensation for performing bookkeeping and administrative services that would normally be expected to be performed by the trustee. In practice, many times the depositor or underwriter does perform such services. The section gives the Commission the authority to prescribe the reasonable amount of compensation for these administrative services, but no rules have ever been adopted under this section. The bank, the trustee or custodian of the trust, must have possession of all the trust assets and segregate them from any other assets that it may hold. And for the protection of the security holders, the trustee or custodian is not permitted to resign until the trust has either been liquidated and all the proceeds distributed, or there is a qualified successor trustee that has been appointed and has accepted the position. Are there any questions about? those terms. Subsection B of Section 26 was added in to the Act in 1970, and it provides that where a unit investment trust holds a single security, the depositor or trustee can't substitute another security unless the Commission approves.
Now, this is a very important feature because this this amendment was aimed at curbing some abuses. People would pay their money in and thinking they were accumulating shares of Fund A, and suddenly Fund B would get a hold of the depositor and say, hey, we'd like to use our fund as a media for this unit trust. And whether or not there was any payment under the table or not, suddenly we would find that the shares of Fund B were being substituted for the shares of Fund A. And here people had been paying their money thinking they were accumulating shares of Fund A, only to find out that they were getting bananas instead of oranges. And which is, if you don't like bananas, it wasn't very good.
So those were basically involuntary, weren't they?
And they were involuntary. Some of them were involuntary. Some of them happened under very suspicious circumstances, and people had no. And the shareholders, all they could do at the time was take their money out or stop payments. Now, when they had front end loads, and they paid 50% of their first year's payment as a commission. To say I'm going to take the shares that I've accumulated out and I'm not going to buy any more, meant that they were losing that front end load, because the way these front end loads operated, and you'll get into that, I'm sure, it ends up, if you complete it, it's only 9%. But these people would have the alternative of getting out after they paid, maybe we're in a year and a half, they paid 50% of the first year, and a smaller commission the second half of the year, so they would have ended up paying about 48% of everything they would have paid going for commissions, which was not a hell of a good alternative.
I think that Section 26B contemplates the sort of deliberate substitution that you've been talking about.
Yeah.
That recently we've been running into some cases where the depositor, there is a substitution of securities in a unit investment trust, but it's completely involuntary on the part of the depositor or the sponsor. And this happens in the case of a separate account of an insurance company organized as a unit investment trust and issuing variable annuities, where one of the underlying funds is a publicly sold fund and is merged out of existence.
Yes, that would be an involuntary thing, and the commission at that point would, in all probability, the staff would recommend, and the commission, and if it had to go to the commission would not object, because there you end up with either that or nothing.
That's right. And we've even taken a no action position where this happened and we didn't find out about it until afterwards, that nobody was hurt and there was nothing we could do.
That's right. But the difference between a no action letter and an order of the commission is, one is an insurance policy. The commission says there is no violation, period. It wipes the slate clean. In a no action letter, the staff says we won't recommend action to the commission, but anybody else can sue, and generally speaking, the commission's no action letter is not relevant or shouldn't be relevant, because that was saying we won't take enforcement action. Rarely, in fact, I would be surprised if the division ever said, we agree with you that no violation has occurred. We'll say, based upon your facts, we will not recommend action. That doesn't, or we'll even say, without agreeing or disagreeing with your facts or conclusions of law, we will nevertheless not take any action. which allows anybody else, any shareholder, the opportunity to sue if he wants to. But once the commission enters an order and says it isn't a violation, there is no suit. It's an insurance policy. That's the big difference. And that's why many people that think they could get no action letters will spurn such course of action and file an application for an order.
Right, and in considering whether to issue an order under this particular section, the Commission would consider whether the substitution is consistent with the protection of investors and the policy provisions of the Act. The last two sections of...
Laura, before you go on, let me just mention one other thing. A number of unit investment trusts, which either in the past or currently uses a funding mechanism, one separate mutual fund, have adopted or brought into the family another fund. Recently in the Fidelity complex that occurred, and the question was, is there really a substitution? The staff took the position that the addition of the fund to the potential investments for in the future would not constitute a substitution. And that no action letter, I believe, went out in July of this year.
Well, it was that, Tim, where the individual had the opportunity to say, I want, instead of funding me with Securities A from A fund, I would like to get into a money market fund, so substitute a C fund for my securities.
Yes, it was the investor's choice.
It was the investor's choice. That's a lot different than having the depositor, the sponsor, do the substitution on his own.
And not only was it the investor's choice, but the investor had the option to continue with Fund A, as you say, with the original fund.
Yes. That's usually a series. They put that in a series, don't they? In other words, there's one unit investment trust with a series A, B, and C. And the investor can choose whichever series he wants to go into, or in some cases he can go into two series at the same time, or two or more series. And he can, at his option, he can substitute back and forth.
The final two subsections of Section 26 are really highly technical and very rarely used. The subsection C deals with the situation where the indenture doesn't meet all the requirements of subsection A, and the parties can then make a separate agreement embodying the missing requirements and file 3 copies of that with the Commission. I think that that's intended to deal with a situation where one of these required terms is inadvertently left out.
Yes.
And finally, subsection D of Section 26 is a procedure for liquidating inactive unit investment trusts. It's intended for use when trusts become orphaned, that is, the trustee ceases its connection with the trust. And in order to liquidate one of these trusts, the Commission is permitted to file a complaint in a U.S. District Court seeking liquidation.
We have never done that as far as I know.
Right, that's exactly what I was going to say. And that about ends
Okay.
what I have to say about Section 26.
As I said yesterday, the use of unit investment trusts have changed in the last since 1970. Previous to 1970, they were used to accumulate shares in mutual funds with the front-end load, and with the concomitant abuses that I mentioned, high-pressure selling of unsophisticated people, door-to-door selling, in which they would claim a 50% sales load. The 1970 amendments made it so difficult for the investment company for a front-end load to exist because of the terms which Tim will get into. That today the unit investment trusts are used in variable annuities, they're used in bond funds with a fixed portfolio, and municipal bond funds. Any other questions? We'll continue on the next tape.